DUI charge is a misdemeanor offense. It can result in your license being suspended for up to 6 months, from you being incarcerated into jail for up to 6 months, but also could result in a misdemeanor conviction being on your record, which would show up in background checks as well as in any time someone does research on you. So hiring a lawyer is the best way you can get the best possible outcome for your case. Your lawyer can fight for you and look at your case from the beginning to the end to see if the police violated your rights, made mistakes, or any other ways or reasons that they can get the case dismissed or have the charges reduced against you and minimize your punishment. So it's very important to hire a DUI attorney that's an expert in that from the beginning. It's much easier to fight your first DUI than it is to try to go back later and try to correct a conviction that you might not have should have been convicted of. DUI is a misdemeanor offense and can result in a conviction being on your record. It can result in jail time, fines, a DUI school, as well as probation for up to 3 years. A first-time DUI can result in up to 6 months in the county jail. Normally, that's not what you would expect to happen for a first-time DUI, but that's the maximum sentence. You can also be placed on probation for up to 3 years. You can be required to take a DUI school from 3 months, 6 months, or 9 months, and you can be required to pay fines that can exceed $3,000. You can also be required to need community service, to install a ignition interlock device in your vehicle, as well as have your license suspended for 4 or 6 months, or even longer. You can also be required to have a special certificate of insurance from an insurance company that knows you have a DUI if you're convicted of a DUI in court or you have a DUI conviction based on the DMV. So those are the possible consequences, and those are the things that your experienced attorney would be able to fight for you, reduce those or minimize those, or even get the charges reduced to something less than a DUI. The specific defenses that may apply for a first-time DUI would vary based on the actual facts of your case. Some cases, maybe they can't prove you were driving while you were under the influence of alcohol. Maybe they can't prove what your blood alcohol level was when you drove. Maybe they can't prove you had alcohol in your system at all. Maybe they didn't have a legal reason to stop you or contact you. Then that could get the entire case thrown out. It's possible that maybe they did not perform their chemical testing correctly, or the field sobriety tests, or they did not have enough evidence to arrest you for a DUI. So they didn't have a right to arrest you or stop you, then the rest of the evidence that they wanted to use against you would be thrown out. So a lot of the defenses you would have in your case will depend upon the actual facts of your case and what the police reports say, as well as what potential video evidence, if any, exists, and what that shows, and whether or not the police reports are accurate or inaccurate. There's many defenses that an experienced DUI attorney would be able to look at based on what the evidence is in your case.